highly globalized world, cross-border transactions are increasing all the time. Over the past couple of decades, from an Indian perspective, we have witnessed tremendous increase in cross-border transactions. Clearly, this gives rise to the issue of taxability of income of non-residents in India. Non-residents are taxed in India on income that is received or accrued or arisen in India or is deemed to be received, accrued or arisen in India. Collection of tax from non-residents is a challenge by the tax authorities. Hence, around the world, generally, a mechanism of deduction of tax at source, or known as withholding tax, is provided. These provisions put the responsibility and obligation of collection of source country tax on the payer. In order to meet this obligation, the payer must ensure that the withholding tax is properly determined. Provisions which deem income to have sourced in India result in conflict. Hence, people engaged in cross-border transactions need to understand them. It is also important that where source country taxes an income element, there should not be double taxation on the same income due to residence country taxation. This is achieved by countries entering into double taxation avoidance agreements known as bilateral tax treaties. India has entered into approximately 85 DTAAs. Under this, India agrees with the treaty partner on allocation of taxing rights in each of the categories in respect of a variety of income categories, and also agrees to provide for elimination of double taxation. There are three types of model conventions: UN model, OECD model, and the US model. The UN model focuses on source-based taxation, whereas OECD and US models focus on residence-based taxation. Most of India's DTAs are based on UN model. A few with the OECD countries and the US are hybrid. As a result, the DTAs with OECD countries tend to be highly negotiated. Under the IT Act, where a non-resident comes from a country with which India has a DTA, the provisions of the IT Act would apply to the extent they are more beneficial than the provisions of the DTA. The difference in tax treatment of non-resident claiming a DTA benefit essentially arises on account of the following. 1. Determining eligibility of a person to fall under the relevant DTA, determining character of income, determining where it is sourced and when it is so sourced. 4. Basis of taxation and the applicable rate. In the 6 sessions of 3 hours each, starting from 24th August and ending on 8th September, we intend to understand all the above and enable the participants to apply the law and the DTA effectively to determine taxability of cross-border transactions. We will start with overview of international taxation, genesis of DTAs, the UN and the OECD model conventions, and how they are structured. The customary international law of treaties, i.e., the Vienna Convention on the Law of Treaties, understand how to read a DTA, how to determine eligibility of DTA, and the articles of the DTA dealing with several categories of income. Elimination of double taxation, dispute resolution, etc. will also be understood. We will also understand the legal position and role of protocols exchanged. Using my extensive experience in advising on taxation of international transactions, I have structured this masterclass to enable participants to have a very good overall understanding and insight of the applicable principles of cross-border transactions. I think that chartered accountants and advisors advising on cross-border transactions, tax heads of businesses, tax officers, and students of taxation will greatly benefit from attending this masterclass. I would be happy to address questions and would invite the participants to send their questions beforehand if possible.